Your Honor, can I
Ma'am,
say something?
no, I have made my decision. Listen to me. You are not taking this seriously. You are not. Ma'am, you will not hear me change my mind. I don't decide things over a bowl of Cheerios. I knew if we had a hearing today, you were gonna at least have this, because I was sure you were drinking when I talked to you and saw you under oath. You're making your own bed. This is like going to Maui compared to what's gonna happen if they turn around and charge you as a felon. I'm telling you, I'm not arguing with you. They'll let you make a couple of calls. I'll move the pretrial date if you want, Mr. Can we do this earlier if she can't post the bond, Miss Heather?
Let me take a look, Judge. The
I'm
Flat
sorry?
Rock case.
Yeah, it's just Flat Rock. I set it for March the 3rd.
Next that we have Flat Rock is next Thursday, the 19th.
I can do the 9th.
Summer Great House.
There's a multitude of probation violations or bond condition violations that are alleged. February 8th, all day on the 9th. I'll be happy to give these to you. The 10th, all day from 11:27. The 11th. So I'm going to hand you this, Mr. Longton. You can look at it. I'm going to conduct a hearing. She can either plead guilty or we can have a hearing as to whether or not she violated the bond conditions. So we'll go off the record. I'll let you two talk and.
Not necessary.
Okay.
Already discussed this with her and gonna plead not guilty and I explained to the court why.
No, that's okay. We'll have a hearing right now.
Right.
But I'm gonna, Ms. Wild, your name?
Elizabeth West, Your Honor.
Okay, so Mr. Longton's advised that she is going to plead not guilty. So are you ready to proceed with the hearing?
I am, Your Honor, as well as the SoberLink expert with House Arrest Services. I told him that if he was needed, I would be able to email or call him and he would be happy to be here present as well.
She still wants us to do that?
Yeah,
If she does, that's fine.
she does.
Okay, call and get them ready, and then we'll start the hearing. Why don't you make an extra copy of that?
I did, just to be on the safe
So
side.
I'll take the original there that I gave to Mr. Longton. And we'll go off the record while you called him. Are we all set?
He said he'll be joining momentarily. He already has your Zoom information. It was just a matter of him, I think, polishing up with what he had in front of him and.
Let's go back on record here.
Right on Zoom.
All right, so I'm recalling Summer Grade House. Mr. Longton's here, Ms. Wiles is here, and Ms. Greathouse is here. So she's pleading not guilty. You can start your testimony. I understand house arrest is going to be zooming in any second, but I'll go ahead and we can start. And then Mr. Longton will have an opportunity to question you. Raise your right hand, please. Do you solemnly swear or affirm under penalties of perjury that the testimony you will give in these proceedings will be the whole truth, so help you God?
I do.
Okay.
Sure. On February 5th, Ms. Greathouse was referred to House Arrest Services to obtain her SoberLink device, which she did do in a timely fashion. I was notified on February 8th that Ms. Greathouse was positive for alcohol at 7:27 p.m.
Yeah.
with a 0.019%.
Wait 1 second. He just told me house arrest is out there. We'll bring him.
Oh.
All right. House Arrest Services. You can start your video, unmute, and state your name, please. There you go. Thank you. Your name?
Yes. Hi, my name is James Hunt.
Okay. The probation director is just beginning her testimony, so we're going to
Perfect.
let her conclude, and then we'll go from there. Thank you. Go ahead.
Yes, Your Honor. So again, just briefly, February 5th, Ms. Greathouse was ordered to obtain the SoberLink, which she did. I received an email February 8th indicating that Ms. Greathouse was positive for alcohol, 7:27 p.m. at 0.019%. For counsel and for yourself, Judge, anything below a 0.020% does not require a reblow, and therefore no reblow was required at that time. On the 9th, as listed on the sheet that council's been provided, as well as yourself, Your Honor, Mr. Hunt does have this information as well. Beginning at 11 a.m., Miss Greathouse was positive at a 0.029%. She called house arrest services claiming this was due to brushing her teeth. House arrest services did inform her to continue to blow as required. So at 11:17, she was and this is a typo on my part, that was 0.023% at 11:17 a.m., Your Honor, again, my typo. At 11:34 a.m., she was 0.23, 11:53 a.m., 0.017, again, under that cutoff, no more reblows were required, but resumed to be positive at 3:26 p.m. at 0.020, 3:44 at 0.013, under that cutoff, no further blows required, continued to be positive that day, 7:22 p.m. at 0.023%, 7:40 at 0.022, 7:57 at 0.019 under the cutoff, continued to be positive that day at 11:22 p.m. at 0.025%, and 11:39 p.m. at 0.018% under that cutoff. Then on the next day, February 10th, she was negative for her morning blow. However, resumed being positive at 11:27 a.m. at 0.023, 11:44, 0.017% under that cutoff. Continued to be positive that day, 3:27 p.m. at 0.040%, at 3:44, 0.033%, at 4:02 p.m. 0.027%, 4:19 p.m. 0.021%, at 4:37 p.m. 0.016 under that cutoff. She did continue to be positive for alcohol, however, again, under the cutoff at 7:29 p.m. and 11:18 p.m. The following day, February 11th, she was negative for her morning blow. Positive again, 11:25 a.m. at 0.025%, 11:43 a.m. at 0.021, and at 12:02 p.m. under that cutoff at 0.016. She continued to be positive under that cutoff at 7:11 p.m. at 0.019%, and at 11 p.m. she did fail to blow. An hour and 55 minutes later, at 12:55 a.m., she did blow, and she was all zeros on her late blow from 11 p.m. Last night. In the meantime, she did call house arrest services, and she claimed that her device was malfunctioning because it was requiring her to continue to blow. House arrest services did inform her that as long as it told her to reblow, that she needed to. This is what happens when we're positive for alcohol. It's going to have you blow until you are under that cutoff to ensure that it isn't environmentals like toothpaste and all the other excuses that sometimes we hear. But the one excuse that Miss Greathouse used while brushing her teeth back on February 9th. I did ask them to send over her contract as well that she signs with them that indicates that she agrees to wait at least 20 minutes after using any mouthwash or any product containing alcohol, such as, but not limited to, hand sanitizer or any other topical substances that may include alcohol like cologne, perfume, bug spray, before she submits a test, as well as she agreed to submit to required tests if requested by the device after a sample had been submitted. There is no issue with Miss Greathouse continuing to blow, but again, it's not a malfunction of the device. Mr. Hunt here is to do his testimony. It's because of the detected use of alcohol that she had to continue to blow, Your Honor.
Okay, do you have any questions of Ms. Wiles?
Do I?
No, you're a lawyer.
Ma'am, you're not technically prepared to testify reliable as device is, correct?
I would leave that up to Mr. Hunt, sir.
The answer is no. You're not totally qualified. My question is a question, I'm sure.
Okay. Mr. Hunt, I'm going to ask you to raise your right hand, please. You solemnly swear or affirm the testimony you'll give in these proceedings will be the whole truth, so help you God.
Yes, Your Honor.
Do you want to ask him some questions?
I'm going to ask him just a brief question in relation to an email, and then I'm happy with Mr. Longton, of course, to ask Mr. Hunt any questions. Mr. Hunt, you and I had talked on the phone. I asked you to review those blows from Mrs. Greathouse in reference to the possibility of that device being defective. And you indicated to me that as a knee-jerk reaction, you did feel that it could be a malfunction of the device, but that you wanted time to look at those blows and make, of course, a more professional decision. And you indicated to me in the email, I'm going to ask you if this is correct, that in looking at each single event, these are consistent with drinking. Is that correct?
That is correct, yes.
Thank you. No other questions, Your Honor.
All right. Do you have any questions of him?
Mr. Hahn. When my client calls Silverland to complain about the device, did she talk to you or to someone else?
She would have spoke to somebody in the monitoring center.
Who would she have spoken?
I would have to pull some calls to get names. I do have a note in here from Miss Hall, one of our monitoring room employees,
And that note says what?
that she called and stated the device keeps telling her to take to test multiple times. We advise her to just keep testing when the device says to. She stated that it may be because she smokes cigarettes. We advised her to reach out to her officer if she has any questions about the report.
What else do you have in your notes?
I have another note in here from a Miss May that says that the client called and stated she brushed her teeth and then left the house and tested on her device.
Do you have any other?
Those are the two notes on her account.
Do you have any notes from your staff indicating that they spoke to her about having the device recalibrated?
I do not know.
How often do these devices need to be recalibrated?
The devices are recalibrated after 1,500 tests have been taken. This device, I'm still waiting to hear back from the manufacturer because this was kind of short notice. But this device has, as of right now, 1,448 tests remaining until calibration, which indicates to me that the device was recently calibrated before given to Miss Greathouse.
Isn't it true that these devices sometimes fail before reading 1,500 tests?
It's technology, so yes, that's certainly possible.
Isn't it true that it has happened and you have a record of these devices failing?
Yes.
So you don't know whether these test results are accurate or not.
But I mean,
You don't.
no, I do not. No.
Got nothing further than this call.
Do you have any other questions?
Nothing further, Your Honor. Mr. Hunt, is it possible to send a device into the manufacturer to determine in this circumstance if this is a device failure or not? Would there be a definitive answer?
Yes, absolutely.
Thank you.
Well, Mr. Hunt, the question is, if you send it back to the manufacturer, can they tell definitively whether or not it has been failed? Are you technically an expert that you could tell us if that's true or false? That the manufacturer can tell us definitively whether or not it's been failing?
I would be able to recite the report that was given, but no, I'm not an expert in device calibration. No.
So we don't know whether or not the manufacturer's report would be definitive or not, do we?
We don't even have that report yet to determine if it's definitive.
I'm sorry, guys, this is just totally cross examined.
Wait a minute. I want to interject.
I wasn't done.
Yeah, let her finish first. Go ahead. You want to ask a question?
Yeah, I had a follow-up question to that, but I
Go ahead.
Mr. Longton chimed in. Mr. Hunt, and it actually alluded to actually what Mr. Longton was. So if we send that device in and the manufacturer reviews the device and we get that report back, that then, piggybacking off Mr. Longton's question, then being the expert, because that is their device, would we know if it malfunctioned or not?
Yes, correct.
Thank you. And I am done now.
And read conclusion that he drew in the email again. Will you do that for me, please?
I can actually read that in whole. Says, good morning, Ms. Wilds. As we discussed on the phone, I went ahead and did some math to figure elimination rates. And these events are consistent with consumption. I have a consolidated report attached, and I also have a detailed report covering her positive dates from 2/9 to today. Knee-jerk reaction, seeing the mix of positive and compliant, was device failure, but looking at each as a single event, these are consistent with drinking. If you have any questions, please let me know. And it is signed by Mr. Hunt.
All right. Do you have other questions?
I have none. I have my comment. That's it.
Okay. Raise your right hand, ma'am. Solemnly swear or affirm under penalties of perjury, the testimony you give in these proceedings will be the whole true self you got. Okay, go ahead.
So what happened during the earliest possible?
I'm sorry, I didn't hear the question.
What happened with sober starting with these early possible days like February? What happened?
On the night, so I had taken a couple of days off since the last time I was in court and I stayed home. And then I went back to work that Tuesday, I believe, and I'm in my car a lot. So when I left this morning,
Wait a minute. Which morning are you talking about?
the 9th, I believe that was Tuesday.
Well, the first one said she was positive for alcohol at 7:27 PM on February 8th.
Talk about February.
8th. What day of the week was that?
February 8th would have been a Sunday.
Honestly, Sunday I was at home with my kids. We played some games, had the football game on. I got them to bed because I had school the next day. And then, so it must have been Monday then.
February 8th is the thing.
Okay, so then starting that Monday, I had gone back to work, back into the office, driving around throughout the
So the
day.
question is, what happened on February 8th at 7:27 PM?
No idea. You know, I didn't ask, I don't remember that it asked me to retest. Honestly, that was on Sunday. I don't
Okay.
remember.
Go ahead. On the 9th, you went to work. What time did you go to work?
I left my house at about 10:45.
Okay, where do you work at?
The office is in Allen Park, but I drive clients around or meet them at different houses. I do real estate.
Okay, so,
So on Monday, I had a client that, well, I went to the office first. We had an 11 o'clock Zoom. I did the Zoom and then I left. I met up with the client, so I did a bit of driving around. When I had gotten the first one, I brushed my teeth, left the house. I do smoke cigarettes, so when I called, I didn't claim that it was because of brushing my teeth. From my recollection, that was the first time it had asked me to retest. So when it happened, I called right away and asked about it.
Who?
I called house arrest. And I said, this is asking me to retest. And so I had asked questions the day when I signed the paperwork, when I got the device, and like Ms. Wilds had explained, like they did kind of go over everything. That was the day that I was in court. Did I necessarily remember the 15 minutes before and all of that stuff? No, yes, I did sign it. There was a lot going on. It was high stress, high anxiety. She went over it.
Let's keep.
Okay, so this day, all day I was driving around clients and I picked my kids up at this 3:26 time. I was with my kids. We went home, we had dinner. That was on Monday. They didn't have any sports that evening.
When is the last time you consumed heavy alcohol? Is it before February 8th, 26?
It was. Yes, it was in December.
Last time you consumed alcohol.
Yes, sir.
Did you consume alcohol on February 9th any time?
No, sir.
So on your device, when you blew at 3:26 and 3:44, did you see these readings on your device?
No, sir.
You don't see these readings?
No, sir.
They don't. And okay, so you just
So I
said
did a
it.
retest. No, sir.
And when you're asked to reblow,
Yes, sir.
when were you asked to reblow?
Tells you to wait 15 minutes.
Right, so on February 9th, how many times did you were you asked to reblow?
The ninth. Felt like every time I did it, that's why I called. And then I wasn't asked to reblow on the 10th in the morning. and I
Let's
think
stick
in-
with the 9th.
Okay, so every time, and I had called that day and I called house arrest. And I said, it keeps asking me to reblow. What could the reason be? She said I could bring it in and have it recalibrated. And then I had.
Did you, well, okay, go ahead. I'm sorry.
So then the next test, I believe, did not ask me to reblow. And then the one in the evening, I think did ask me to reblow. And then the next day, it didn't in the morning, and then it did a couple of times throughout the day. I think that one was the day that it asked me multiple times, or maybe not.
Let me ask you a question.
Yes, sir.
I ordered you to go and get the sober link the day you were in court. That's February 5th, right?
Yes, sir.
Did you go on the 5th?
Yes, sir.
Did you have any problems when you blew into the machine on the 5th after you acquired?
The first machine they gave me was not working, so she gave me a second one, and then no,
Before you left?
no.
Wait a minute, slow down. Let's slow down. You went over to house arrest on the 5th
Yes, sir.
in Livonia.
Warren, Warren.
Warren, I'm sorry. Warren,
Yes, sir.
you said she replaced the machine?
The first one she gave me was not working.
And did she replace the machine before you left house arrest?
Yes, sir.
Okay, so you went back from house arrest on the 5th, right? With a workable machine, at least in your mind.
Yes, sir.
Did you have any problem when you blew in that machine on the 5th?
No.
Did you have any problem when you blew in that machine on the 6th?
On this, I don't remember if it was.
Well, let's,
What was the
wait,
date?
whoa. Let's not guess. The 8th was Sunday.
Yes, sir.
The 5th would have been Thursday.
Yes, sir.
You got the machine on the 3rd, on Thursday, the 5th.
Yes, sir.
You didn't have any positive blows with it on the 6th, right? You didn't have any positive blows with it on the 7th. Wait, let me finish. You didn't have any positive blows on that machine on the 7th, did you?
No, sir.
And when you woke up in the morning, when is the first time you tested on the 8th?
Would have been between 6:45 and 7.
Did you have any positive blow on that time, on that occasion? Well, any problem with the machine testing inappropriately until at least 11 o'clock on or about the 9th of February?
It was the 8th.
Okay, you're right.
The only issue.
Wait a minute, slow down, my mistake. On the 8th, you blew positive at 7:27 PM, right?
Yes, sir.
How many times did you test it on the 8th prior to the 7:27 positive blow?
I tested 3 times.
Any problems with those results when you blew on the 8th prior to the 7:27
No, sir.
blow? Any problem with the machine when you blew on the 7th?
Not with a retest. The only issue I had with the machine that Saturday was that it wasn't turning on. And when it finally did power on, it had battery. So it wasn't that the battery was dead. That was kind of when it's. I didn't think much of it.
Any positive blow on the 7th? I'm asking you.
Oh,
Any positive blow on the 6th? Okay. Anybody have any other questions on that? Go ahead.
Your testimony been completely candid?
You got to keep your voice up for me, though.
up.
Yes.
When you heard, has your testimony been completely candid?
Yes, sir.
The last time you had a drink was in December.
Yes, sir.
You willing to take the polygraph?
Yeah, we.
They're much more reliable than they were when you and I started practice law. And Taylor Police Department has a polygraph, and they're more than happy to pay for the polygraph. Because otherwise, you're going to make a decision based on a device that could well be defective.
It could be, and if if I am not satisfied by a preponderance of the evidence that she consumed alcohol, I'm gonna find her not guilty. No, wait, just wait. Let's not, I don't want to talk about polygraphs. You ask your next question. Mr. Hunt, I want to ask you one while he's thinking.
Yes, Your Honor.
I want to make sure I understand. You said maybe every 1,500 blows, it has to be recalibrated. Right.
After 1,500 blows, yes, is due for
You said
recalibration.
this particular machine, based on your inspection, still had roughly, I think you said, I want to double check, 1,444 blows left.
1448.
1,448 blows until the machine needed to be recalibrated.
Correct, yes.
Go ahead.
Mr. Hunt,
Yes.
last year, 2025, were there machinery that turned out to be defective before there were 1,500 blows?
I'm sorry, can you say that again?
Last year, January through December of 2025, were there devices that turned out to be defective and needed calibration before 1,500 blows?
Yeah, it's technology. Things can fail. That's absolutely true.
And you had devices that did fit, correct?
Yes.
DNA open today?
But on-site is, Your Honor.
Good.
Yeah.
What else?
Your Honor, I have the greatest confidence in my client that she's telling me the absolute truth. I think it would be a horrendous miscarriage of justice to have her guilty based on what you've heard today from both her and Mr. Hunt. And I know you don't want to hear anything about polygraphs. I understand why the District Court of Appeals is clear about that. But in all honesty, when you and I practiced law, they were only 60% effective. Today, they're 98% effective. I'm more than happy to have her polygraph as a tailored PD.
How do you explain the fact that this machine was working on the 5th, was working on the 6th, was working on the 7th, and worked until 7:28 or 27 properly on the 8th, and then all of a sudden she starts blowing positive, and now there's a problem with the machine?
And we don't have the testimony from the factory to answer that question as to whether it could work properly today, fail tomorrow, and work properly 2 days later. We don't have that kind of technical testimony. Mr. Hunt's already testified he relies on the factory for that kind of. When I told my car this afternoon to come here, my brand new Jeep would not start. I had to go back in, call the dealer, come back out. Eventually, it started. Who knows why? They don't know why. Who knows why, whether or not this thing fails every other day or failed all these times? We don't have the technical testimony from the factory. I don't have it.
I don't, this is not, we deal with these machines all the time, Mr. Longton. SoberLink devices are accurate. Once out of every 500 defendants will somehow, some way, when they get results like this, want to try to insist that there's something wrong with the machine. There's nothing wrong with this machine. They don't need to prove beyond a shadow of any doubt that the machine is working accurately. It's pretty evident here. He told you what it needs to have to recalibrate, or how often it needs to be recalibrated. He said it still had 1,448 blows left. It's clear it was working on the 5th, the 6th, the 7th. And based on these results, when you take them, I've got testimony from Mr. Hunt that it's consistent that the amounts would reduce like this. Yes, listen. I don't think there's any question in my mind but that she was drinking. Okay? I get this all the time. And there's no question in my mind that she was drinking. And I'm not going to order a polygraph. I'm not sure I don't want to send her for a test. But I'll tell you what, I'll send her for a test.
If she flunks, put her in jail. Because I'm confident she's not drinking.
If she flunks on this test, I will put her in jail and she will remain in jail. I will set a bond she won't be able to set because I've just then, in my view, as I believe now, I've had somebody commit perjury in this courthouse, and I don't think very kindly of that. So yes, let's have her go to on-site today.
Yes, sir.
Now, I am not going to be here tomorrow, but I will be more than willing to Zoom tomorrow. And we can Zoom on this case at 9:30 in the morning or 10 o'clock in the morning. You available, Mr. Longton?
I will change my schedule.
We'll Zoom on this case at 10 o'clock.
Judge, what I could do is I can have them send it straight to the lab. It won't be a screen, which would probably be more preferable. I assume Mr. Longton would prefer that as well, since he wants the actual results. So she can submit to her test today at 4 p.m. at on-site, and they can actually send it to the lab. Now, those results won't be back tomorrow. Should be back Monday or Tuesday. Court's closed
What
Monday.
does trouble me though is, yeah, let's do that. I'll do that. We'll continue the hearing at 10 o'clock. Now, I'm going to give you one last opportunity.
Yes,
I'm going to let you go test. If that test comes back positive, as opposed to me finding you guilty right now, I'm going to set a bond you will not be able to make. Do we understand? Maybe you need to go confer with your lawyer. I've been doing this a long time, young lady. I can tell who's telling me the truth or not. I don't pretend to have every answer, but I'll tell you what, I'll compare my ability to determine somebody's credibility with anybody's. And I don't believe for 1/2 a second that you're telling me the truth. And then if you go and test and I have confirmation that you've committed perjury in here, you are going to have a massive problem with me. It's going to be so big of a problem, you're not going to want to, you're not going to believe how bad it's going to be. So I think before I send you for that test at on-site, you need to go confer with your lawyer for a few minutes. And after you confer with your lawyer for a few minutes, if you two want me to still order you to go to on-site, I'll order you to go to on-site. But do this, listen, don't talk to him now in front of me. Go take a few minutes, but think very carefully about what you're about to get into, okay? Do we fully understand one another? Okay, all right, you guys go talk. We can reconvene in here in a few minutes. Thank you.
We all set with Mr. Hunt, Judge.
Mr. Hunt, unless we call you again, thank you very much for your testimony. Mr. Longton, do you need any more
Of course.
from Mr. Hunt?
Your Honor, I only had one question.
Well, I'll tell you what, you go talk to your client and he'll come back in here. Will you zoom back in at 1 o'clock and we'll reconvene at 1?
I sure can. Absolutely.
Perfect. 245-336.
Hold on, Your Honor, but Your Honor, I asked her what the last time she had it. She excluded the fact that she's been drinking non-alcoholic beer and And my question for Mr. Hunt would be, would that create a positive test? I don't think it would if manufacturer's representation contains accurate. It's almost 0% alcohol, but I don't know.
We're just gonna follow this little circle around. We're gonna follow the circle around. I just want to know, does she want to get tested?
Yeah.
If she does at 4 o'clock, I'm sending for a test, and we are going to reconvene here at 9:30 or 10 in the morning. If she doesn't, sounds like she's already changing her story. I didn't hear one thing about a non-alcoholic beer until you just mentioned it. Not one, not even close. There's no remote reference to a non-alcoholic beer. So this is what I'm trying to tell you. I don't want to sound like a know-it-all, but I've seen this movie. I've seen this movie thousands of times. And if she wants to go for a test, I don't mind sending her for a test. But I don't hear this nonsense about non-alcoholic beer. Now I'm hearing, Ms. Wiles, you're just walking in, about she's drank some non-alcoholic beer, and would it be positive? So I want Mr. Hunt, I asked Mr. Hunt to show up here at 1 o'clock. And I'm hoping he's going to log in now. Do you see anybody from house arrest out there, Heather?
I do not, Judge.
Do you have your phone, Beth?
I do not, I'm typically one vehicle.
So, I just see this perpetual denial. You know,
There is an alternative. That is that she's correct. And
there is an alternative, like there's an alternative that I could pogo stick to the moon too right now. I mean, there's a possibility that some Martian could come grab me. I mean, look, it's fine. We'll send you for the test. I'm only telling you, I have one set of bond in mind if I don't think that you perjured yourself. And I have another set of bond in mind if I do think you perjured yourself. Okay? And if I send you for a test and it confirms this on top of what I have, I will be 1000% convinced that you perjured yourself. In which case, I'm going to set the bond that I would set if I'm convinced that you perjured yourself. I don't have any problem with you going for a test. You want to go for the test? You go for the test at 4 o'clock. We'll reconvene here at 9:30 or 10. Mr. Hunt, I told him one, I didn't want to have to wait.
Your Honor, may I have another moment with my phone?
Yeah, you can have another moment, but
Your Honor, you've been very clear. So allow me.
I know. I'd like to think I'm clear. Do I have this other person's file here, Heather, this gentleman that just came down?
Yes, she just brought him down.
Come on up here, sir. People against Kevin James LeBeau. 26W841086A and B. How you doing, Mr. LeBeau?
I'm okay. How are you?
Your name?
My name is Kevin James LeBeau.
What do you need? Time to pay?
Yes.
Okay, how much do you have today?
Today I have a total of $400 to my name, but I'm behind on a lot of my bills.
Do you work?
Yes, I do DoorDash, but I also do all the driving and guarding care of my mom, who was diagnosed with early stage dementia last February. But
Okay, let's slow down.
sorry.
I'm gonna help you. Okay, at least you had the courtesy and respect enough to come in here. You owe $165 on file A. Listen to me. I will reduce that and charge you $110 right now, and you can be done with that ticket. Is that fair?
Yes, sir.
Are you sure?
Yes.
Okay. Now you got another ticket of $215.
Yes.
I can reduce this one for you to $150 and waive the balance if you can pay it today. Otherwise, if I'm gonna set up a payment plan, I gotta have you pay the whole thing.
I'll pay it today, sir.
Good enough. So see,
So much.
you pay $110 and you pay $150 on the other one. Balance is waived. And you're all set. I wish you were. You're welcome. Good luck. You have a valid plate now, right?
I'm trying to get,
You got to get insurance in a plate, sir.
I know, I'm trying to get it. I came down here to figure out these fees.
You're all set. Go down the hall, pick your date. Good luck. Thank you. We're off the record, right?
No,
Wow.
Yeah.
you want me to?
No. Keep it simple.
I'll turn that on it. Okay.
Did you call him? Or not?
Like since,
Yeah.
no, I didn't call him, like, since you said to rejoin at 1, I did not recall him after that.
I'm watching for him. He should not have been here. Hopefully.
Yeah, I believe he is, if my memory serves, he's in Florida, Your Honor.
Well, he's the smart one. Would you do a favor and call over?
Here he is. Here he is.
Mr. Hunt, we're waiting for the other party. Went back on record and he needed to go talk to his client. Just bear with us. It won't be long.
Fair enough. No problem.
Me, Amy, I guess when I was on vacation, she helped teach Pam or teach Jess how to like actually use our thermometer, which has been like broken. It is so nice in our department. You'd be jealous.
Right, that's all.
Yeah, it's like seven.
Actually, it's so warm.
You're in Florida, Mr. Hunt?
South Carolina.
South Carolina. Nice.
Couldn't do those Michigan winters anymore.
Oh, you live there in South Carolina?
I do. Yeah. I moved here about 5 years ago.
Whereabouts?
Myrtle Beach.
Nice.
Yeah.
Nice.
Lots of
Yeah,
golf.
This has been a brutal winter.
Oh, it's came this way too. We got 8 inches of snow a couple weeks ago. So it was
It's
pretty
crazy.
wild. Yeah.
We're probably just talking.
Like a new report on your phone. It's really hard, like it's static.
It's just the phone.
Is it the
I think
phone?
it's the phone. He changed the cord.
Sometimes it doesn't even work.
It's hard to hear
I
you.
know.
You sound like you're,
Ever since they switched to the new phones, remember the old phones we used to have?
Mhm.
When they went to the new phones, everybody got a call from this phone, can't hear.
Recalling Summer, we were back on record, right? Summer Lori Greathouse, 25F 245-336. Okay, everybody's name again. Your name again.
Oh, yeah.
Ma'am, your name.
Summer Great House.
Elizabeth Fospation, your house.
Mr. Hunt. Your name again, Mr. Hunt.
James Hunt.
All right. What is she want to go for the test or what?
Yeah, can I ask Mr. Hunt just one question?
Sure.
Mr. Hunt,
Yes.
do you acknowledge that the device can malfunction one day and function normally the next day? Is that possible?
I have not seen that in my experience. No.
So you're right, we're gonna change our,
I don't want her to sit here now.
I'm sorry.
So just so you know, I'm going to make the decision because I'm going to spare her the disgrace of just admitting to me under oath that she has committed perjury. I mean, I will do that if you want. I don't want her to plead guilty now when she just testified under oath that she hadn't consumed anything until she came back and said it was non-alcoholic beverage. So if you're telling me she's not going to go for the test, I'm simply going to make my finding right now. And there's no reason for her to change her plea because honestly, I think it's horrible if I'm going to sit here and have somebody admit that they just committed perjury in front of me. So that's what I'm suggesting to you. If you want a different route, you can do that. I get it, Mr. Longton. But I still think, even though I'm upset that somebody would do such a thing, I still have a function here and I'm going to do it to the best of my ability. And that would be my advice to your client. But that's not, she need not take advice from me. So if she wants to just say, if you want to tell me, Judge, we don't see a necessity to go for the test at 4, then I will simply make the findings based on what I've heard here, testimony from your client, from Mr. Hunt, and from Ms. Wiles.
That would be correct, Jim.
Okay.
She will not continue.
Okay, so I'm gonna simply, I'll listen to argument if you want. Do you want to argue or you want me to just make my findings here?
You're fine.
The court finds that the machine was properly working, that the defendant consumed alcohol, and that the document, which Ms. Wild signed February 12, 2026, evidences that intent, or evidences the results. And also, I'm going to find you guilty as charged. Now, you and I are going to have a conversation, young lady. You should have been charged with a felony. You should have been charged with a felony. Now, I don't know why they didn't charge you with a felony. I don't know. I don't care. It's not my business. I just do what they put here in terms of files. Now, in my view, you needed sobriety because I still think we can help you. But if you come in here and you lie to me, there is no way in hell I'm taking you in sobriety court. Excuse my language. I should not have said that word. Ma'am, don't say anything. You should not be saying anything. You are the whopping old age of 30, what, 8? And this is now your 4th offense. And judges don't like this when you have 4 offenses by the time you're 38. They should have, like I said, charged you with a felony. I'm not being punitive when I do what I'm going to do here, but you're scaring the devil out of me right now. Because when you have a judge tell you not to drink, and you've had 3 offenses, and you've had a sober link device, and then you come in and you tell him under oath that you didn't drink alcohol, and he knows that you're lying, I can't help cure somebody who is not going to admit that they are drinking. I get it, that they have an alcohol problem. I get it. There's a form and an element of denial. But honestly and truly, you are going to live a short life if you don't get off of this stuff. It's your life. It's not mine. I have no choice here but to forfeit your bond. I am forfeiting the bond. That means you're losing your $500, and it also means you're going to have to post. And it's a good thing that you guys didn't go for the test just to verify what I was listen to me, what I was 100% sure of, and that is that you had consumed alcohol. I'm forfeiting that bond. I made a mistake when I only gave you a $5,000 bond. Ma'am, I'm going to explain it to you. I gave you a 5,000 10% bond. You know why? Because you told me, as I recall it, you only made about 50,000. Well, that's why I gave 5,000 10%. Because I thought, well, I got to run a sober link. She's had 3 priors. Maybe she'll understand that this judge is a little bit serious, but I still cut you a break. And now you go out and you drink again, and you come in here and tell me what I know are lies. 60,000 10% is the best I'm doing. 60,000 10%. You're going to have to post $6,000 to secure your release. I have a pretrial date. Make sure any warrant that was entered is canceled. And
If you have to go tomorrow.
I'm sorry, Mr. Longton.
There's no way.
There's no way in heck I'm letting her out. She scares me.
Listen,
Nesman and Janae, give me your phone number, or give me your names, please.
J. Janae. Jazz.
Last names.
Matthews.
Last name. Janae.
Matthews.
They're not applying for funding, but they did ask to speak to a lawyer. So I'm not going to be here next week. So we're going to adjourn this to the 27th of January at 11. And you can tell them the total amount that they owe, if you would, please. I don't need a breakdown right now.
Yes, $670.25, Your Honor.
Ladies, pay that, and the case will be just dismissed. Okay? You understand that?
Yes, I
Guys,
understand.
come on, you got to talk to me.
Yes, we understand that, but we don't agree with the amount.
How much do you think you owe?
I don't think we owe anything.
You think you paid this in full?
No, those fees are,
Ma'am, just please listen to me. The greatest, easiest thing about math is there's only one right answer. So you can't say about, or I don't know. If you don't know anything, that's fine. You guys can figure that out. If you do owe something, I need to know to the penny how much you owe.
I don't think we owe anything.
Did you pay January's rent?
Yes. Yes.
Miss Austin?
They did, Your Honor. I'm sorry, I just got kind of pulled into this last minute. It appears that there was some prior court filings. So there's some court costs of $146.43, which is our cost without the statutory attorney fee. So they did pay January rent, but it looks like there's some court costs going back into.
Yeah, but
filed
you can't add those in, can you? I mean, if they paid it and you guys dismissed it, is that what you're telling me?
Well, I didn't add this. No, I didn't. Well, I'm telling you, I added the cost of filing the case prior to the hearing. So there's no statutory attorney fee charge because we did not come to court because we dismissed, but the actual charge of filing the summons and complaint, getting them served, doing the second mailing, that I do pass on, Your Honor, because I did incur that expense, even though they
Yeah,
were,
but why are you guys dismissing the case then?
because they paid prior to the court hearing.
Yeah, but they didn't pay in full with the court costs.
Yeah, I don't, again, Your Honor, I just.
Why
they
don't you guys talk? You come back January the 27th.
Judge, we can have them come back at 9:30 on the 27th, if that's okay with you.
I've got court to school. Is that going to be good enough?
From what I am told, yes, that should be fine, because that was their only
9:30
one
on
that
that
day.
date, you guys.
Perfect. Thank you, Your
9:30,
Honor.
January 27th at 9:30. Make sure you change the time, okay?
Perfect. Thank you, Your Honor.
Thank you. Have a good day. Bryant Allen Kinney, 25B-148-464. Detective, your name?
Detective Platt, Brownstown Township Police Department.
Counsel?
Good morning, Judge Mazzagate, appearing back Mr. Kennedy with this with Zoom.
All right.
Okay, we agree to go.
Not guilty, please entered. Has he been printed yet? Your name, sir?
Bryant Allen Kinney III.
Has he been printed yet?
Your Honor, I am not sure. I will. He was printed last night. Yes, he was printed last night according to him here. Yes. I will confirm that.
Where's he been?
You're talking with you.
Yeah.
Judge, I spoke to Mr. Kenny.
He walked in here before he starts giving you stories.
Yeah, I did read the ROA.
Yeah, he walked in on August 4th, and apparently we didn't get to him fast enough. He just decided he was going to leave.
He walked in with Ms. Coates, which is one of the complaining witnesses, the judge. Heard there was a disagreement, and then he ended up walking out. Since that time, Judge, Mr. Kenny's had a number of mental health breakdowns and a number of issues. He's been in counseling since October 2025. He's been going to counseling once a week. He apparently reconciled with Ms. Coates, Judge. They are currently living together. They share one child in common, and she is currently pregnant with their second child. He's been moving around a lot since. I did update his address in the court file. And Judge, he is currently a stay-at-home dad, and he's the only one that cares for his son because his wife is the one that birthed.
Do you know anything about this, detective? I'm asking if you know anything about a reconciliation or her not wanting to proceed with charges, it sounds like.
I don't know anything in regards to this case. I'm sorry. I just know what the report has in it.
Mr. Kenny did advise me that he would, I'm sorry. But Mr. Kenny did advise me, Judge, that he would call Ms. Coates, try to have her come down and actually state that to the.
Well, he's not gonna have any contact in the meantime. I'll give him a personal bond. I'll do that for him, assuming that to be the case. But you can't not show up, sir. You also have a second file here that you, 25T645723, that I'm going to, Paul, and does he stand mute on this one?
Judge, he'll plead guilty of failure on that.
Is that what you want to do?
Yes, sir. Yes, Your
Plead
Honor.
guilty here, you could get, it looks like you could get 322, 317, you could get 32 days. Do you understand that?
Your
Sir.
Honor,
Sir? Sir,
Just answer the judge's questions, Mr.
do
Kenny.
you understand what I just asked you?
yes, I do.
You understand that?
Yes, I understand.
If you plead guilty, you're giving up your right to a hearing. You're waiving the presumption of innocence. You're waiving the requirement that they prove you guilty by a preponderance of the evidence. You're waiving your right to remain silent. You don't have to plead guilty. If you plead not guilty, we're going to have a hearing. You can question their witnesses, bring in your own, use the subpoena powers of the court to bring in those witnesses and testify or remain silent as you so choose. You plead guilty, you're giving up all those rights and we won't have a hearing. Do you understand that?
Yes, Your Honor.
To the charge then that you failed to pay $317. How do you plead? Sir, talk to me, please. How do you
I
plead to that charge?
I plead guilty.
Did you fail to pay?
Yes, I did.
Anybody forced you to plead guilty?
No.
All right, I'm gonna accept your plea. Does he work?
He doesn't work, Judge. He's stay at home dad. His fiance is.
When can you pay this, sir?
So today we've only got $400 today, and Kimberly is on her way here with all of that money right now. And she gets paid bi-weekly. So in 2 weeks from today, she got paid today. In 2 weeks from today, I would have, another amount of money.
Judge, would the court, considering Mr. Kenny's finances, would the court be able to waive any penalties or late fees to somewhat reduce the?
Here's what I'll do. Have her come up to the court. You pay $200 today, I'll waive the balance, but defendant still must pay the clearance fee. There's a $45 clearance fee, so have her come to the court with $245. I'll give you a personal bond on the other case. I mean, I have a little bit of hard time giving you a note based on just what you've told me, not ordering no contact.
Judge, can we move into the court order no assaultive contact?
I'm gonna do that. Here, no assaultive, abusive, or intimidating behavior toward the victims. You cannot leave the state without the consent of the court. You cannot violate a law. You must appear in court as directed. $2,500 personal bond. Mr. Kinney, you miss again. I'm gonna set a high cash bond. You're gonna be waiting. Do you understand that?
Yes, Your Honor.
You're gonna be waiting in jail is what I'm trying to tell you nicely. Don't do this again, okay?
I understand, and thank you very much.
So have her come up here with 245 on the civil infraction. I'll waive the balance. We're gonna give you January 28th at 9:15. Okay?
Yes, sir.
I wish you well. And have them fill out a petition for a court-appointed lawyer. Wait, don't go anywhere. What's the question?
I mean, I think he may need to call her again. Would he be allowed, would they allow?
Let him make a call and have him, you tell your girlfriend to come up here and she can pay the 245 and he's gonna release you once he gets word that she's
Okay.
paid the 245. So, let's see, who do I have? Jennifer, can you tell Stephanie or somebody call Brownstown and ask for Detective Claft once we have the 245? And they're gonna release him. Okay?
Okay,
Thank you.
you're welcome.
Thank you, Your Honor.
Thank you very much. Good luck, sir. You gotta show up in court. Don't do this again.
I will
Thank
absolutely be here on the 28th.
Thank you. Brenda Ice versus Bridget Ekman, 2505292.
Good morning again, Judge. Jen Wilburn, P83143 for plaintiff.
Is Bridget Ekman here? This was scheduled for 10. I give them 15 minutes. Is she here yet, Jen?
Judge, she did not appear with us.
Okay, how about Giovanni Boudry? Is he here?
They
Come
are
on up
here. They
here.
are on a device. Oh, yep, there they are in the courtroom.
Brenda Ice versus Giovanni Boudry, 2505293.
Jen Wilburn, P83143 for plaintiff.
Your name?
My name is Giovanni.
Did you listen to the rights on the video? Did you understand them? Do you wish to speak to a lawyer? You intend to apply for funding? Ms. Wilburn, why don't you tell me how much is owed?
Judge, there's a rental balance of $1,500, 2 late fees at $50 a month. So the subtotal is $1,600 plus the court costs, which I show as $184.17. So total would be $1,784.17.
You pay that?
Not at the moment.
When can you pay it?
I start a new job tomorrow and it's bi-weekly pay, so I'm gonna have to wait 3 weeks. But I I deny non-payment. I have proofs that I did pay. I have pictures that I sent to the landlord of my money orders right before I put them in his mailbox.
When did you put them in the mailbox?
Right after I sent the pictures to the landlord. They're different pictures I have different times.
I don't know what that means. Did you send them recently, the payments?
Yes. He only accepts money orders and checks, so I do money orders and I deliver them to his, I believe it's his financial office, and put them in the mailbox. That's what I've done since I moved in.
You know anything about this?
I don't, Your Honor. Depending on when it was placed in said mailbox, I don't know when that happened. It may not have been processed.
Here's what I'm gonna do. I'm gonna adjourn this to the 27th. I want you to call up Ms. Wilburn sometime today. Give them a piece of paper, will you, John? And you call her up and you compare notes and you find out what is owed. If you guys can't agree, I'm setting it for trial. Okay? You said how much is owed, Ms. Wilburn?
I show $1,600 plus the court costs of $184.17, total
$1,784.17. And he says you say you owe nothing?
Yes. We only had, so last month was our first time going past the 15th.
You pull out all your payments. You should copy those. You should attach a ledger that tells me when you paid and how much. How long have you lived there?
It's been about 7 months.
Okay, then that should be easy to do. I'm adjourning this to January the 27th. At what time?
11 o'clock, Judge.
Do you have one already set that day, Ms. Wilburn?
I do, Judge. We're coming at 11 that date.
Okay, perfect. January 27th at 11. Okay, January 27th at 11. Thank you. Good luck. Truman Estates versus Cody Kaler, 25. Wait, Ms. Wilburn, give him your phone number.
Oh, yeah.
Absolutely. It's 734-287-3664. That's our office number. You can ask to speak to me directly.
Okay, Jen Wilburn, Wilburn. Truman Estates versus Cody Kaler, 2505294.
Jen Wilburn, P83143 for plaintiff.
Judge, he did not appear with us. This is technically the first hearing, and he was personally served.
All right, you can go ahead and take a default.
Judge, this is for possession only. The outstanding rental balance is $1,294, one late fee of $50 for a subtotal $1,344, plus the court costs, which I show as $184.17. Grand total $1,528.17 to be paid by January 22nd.
Defendant failed to appear. Default judgment is entered. I'm going to just ask you that you make sure you get me these judgments here early this morning if you can. Writ date will be on the 22nd.
Absolutely, Judge. I'll get them in as soon as we're done.
Have a great day. Thank you. LMV versus John Zukowski, 2505334.
Good morning, Your Honor. Gary Russell appearing on behalf of LMW.
Is John Zukowski here?
Judge, he did not appear with us. He was not served. I have a note here from our court officer saying he spoke to the attorney and he said he did not want to pay for the service, and that was on the 8th.
What?
Judge, I'll try. So it sounds like the process server was contacted and told that they didn't want to pay for personal service, that the mailing should be sufficient. We received a call late last week and there wasn't enough time for the officer to go back out. The defendant did not appear today, so we're going to have to adjourn it and have it served.
January 27th, at what time?
11:30.
I don't know what that means. I mean, they have to go. They can't tack until the third time. I don't know what that
Correct.
means. So what's he going there the first two times, Mr. Russell? Is he just going there the first two times and pretending like he wants to serve it? I don't get it. I'm not sure I understand it, but
It's
Usually my client hires his own process server to serve.
well, tell him to stop doing that. He can't be saying, I don't want to pay for personal service. What does that mean? He goes there the first time, the guy answers the door and he doesn't serve it? Makes no sense. None. Tell him to stop doing that. Okay?
I don't know what you're saying, Judge. No, he hires a professional process server to serve usually in most of his cases. That's why when the court called, we weren't aware of it. We thought he already had a guy going out, so we said, don't have the court officer do it because we thought he already had his professional server out there doing it.
Okay. Well, I thought she just said, I could be wrong, I can stand corrected, that the plaintiff did not wish to pay for personal service. Is that not what you said, Jennifer?
The note from the court officer says spoke with attorneys, said wasn't paying for service. So maybe they thought that, but they didn't have a process server turn in a proof. So even if our officer was attempting, theirs wasn't apparently.
Right. They haven't got personal service. That's correct. We only got the mailing service at this point. That's correct.
Well, I don't have a proof of service though.
No, through the requested second service through the court by mailing. We submitted that form when we filed the case.
Correct. We mailed it out, but we still need a service by personal or
tacking.
Well, yeah, for a money judgment, correct.
No, for both.
Oh, you still got to have service. It's either tacking, which requires them to go 3 times before they tack, or personal service. This isn't just mail a first-class letter to somebody and that perfects service. That's not right. That can't be done. You get what I'm saying?
I understand your interpretation, Judge. I know
It's not an interpretation. That's like 2 and 2 is 4. You can't just mail the first-class letter and not have tacking or personal service and act like service is perfected. Now, if he shows up, he's submitted to the jurisdiction of the court. So he's going to have to go out and perfect service. And he's going to have to do it. I'll give you that new date, but there's no interpretation that I know of, none whatsoever, that says you can just mail a first-class letter, have the court do it, and that's good enough to be service if there's no tacking or personal service. That's just not the law. I'm sorry. January 27th, we'll see you here. Thank you. Wendy Tucker Beck versus Lisa Summers and Stephen Summers, 2605336. How's that interpretation?
Yes, Your Honor.
Good morning, ma'am.
I'm
Your
here.
name?
I'm Wendy Tucker Beck, Your Honor.
Do I have Lisa Summers or Stephen Summers here, Jennifer?
Neither
Let's see
one
who-
of them have checked in with us, Judge. Lisa Summers looks like she was substitute service, and then Stephen Summers was personally served. Both were second mailing.
Okay, so you get to go ahead and take a judgment. You got to tell me how much is owed though, ma'am. Okay, how much is just owed in rent? Just rent.
$6,600.
Just in rent?
Yes, Your Honor.
Not including any late fees, not including any unpaid water bills or court fees, right?
That is correct, Your Honor.
Do you have any late fees?
I do not.
You never charge late fees?
I've never charged them a late fee, no.
Okay, what is unpaid water bill? Do you have any of that?
Yes, the unpaid water bill is, let's see. The unpaid water bill is $350.
Okay, so they owe $69.50. Do they owe, and then plus your court costs? How much do you have in court costs?
I have $225.81. That was for court costs, mailing fees, and.
That's fine. Is it
having-
7175.81?
Yes, yes, Your Honor, $7,175.
We're gonna do
Judge,
the,
I'm sorry
yeah.
to interrupt, but if I may, I do see that Lisa Summers is here in the waiting room. It looks like we just let her in. Well, wait a minute. Did you let her in? Okay, never mind. Go right ahead. She was right there and now she's gone again. Carry on. I apologize.
Okay. All right, so that's the amount that's owed to you, right?
Yes, sir. I did not include all of the fees for traveling down there. I was in your courtroom last Thursday
You can't charge travel fees.
No, but I'm also being hit with blight fines from the city because of two defunct motorhomes that they have on my property, on the property, and I'd like to ask for permission to have those moved. I will pay for them to be
What is this
moved.
for? Is this a mobile home?
Motorhomes. They have two non-working motorhomes on the property, and I was in your
Slow down a
courtroom last.
second. Slow down a second. What are you renting to them?
I'm
Judge, she
renting
is
the
back
house
in.
to
She
them.
just popped up.
Hang on a second. Let's go back. Ms. Summers? Ms. Summers, you have to start your video. Ms. Wilburn, I'm not sure what you're here on. Do you have another one?
I do, Judge. We passed on it because it was only a couple minutes after. It was for Brenda Ice and Ekman.
Jack, can you find this for me? I don't know. They should be one of these. Rendez versus Akron. Ms. Summers, your name? Ms. Summers, your name?
Brenda, he's yes to that.
Ms. Summers, can you hear me? Ms. Summers, can you hear me, ma'am? Can you chat with them, Jennifer?
Yes, Judge, I just asked them to connect their audio.
Let's go to Brenda Ice versus Bridget Ekman, 2505292. Your appearance?
Jen Wilburn, P83143 for plaintiff.
Brenda Ekman is not here, right?
That is correct, Judge.
So what did I do? Did I adjourn this just because it wasn't 15 minutes?
Correct, Judge.
All right, go ahead. I'll give you a default.
Possession only, outstanding rent, $2,800. Two late fees at $50 a month for $100. Court costs $184.17. Grand total $3,084.17 to be paid by the 22nd, and I will file that in a moment.
Defendant failed to appear, 12226 will be the writ date, default judgment, 308-417. Yeah, if you can get me those now, that would be helpful, okay?
Yep, the other three were already filed.
Thank you very much with Ms. Wilburn. Have a great day.
You too, Judge. Thank you.
All right, I'm gonna wait till they bring in Ms. Summers. This is the problem with Zoom.
It appears that she disconnected again, Judge, so maybe give her just a few minutes, see if she can reconnect.
What's this gentleman?
He's for 10:30.
10:30?
Yep. Sir.
I want to wait until they come in. What is on your property?
Your Honor, the defendants have two motorhomes on the property that do not work, that I am being cited for blight on.
Wait. You're leasing property. Is that a house or what is this that you're leasing?
I'm leasing them a house, Your Honor,
And they have two inoperable motorhomes that are on your property and you're getting cited by
yes.
City of Rockwood for that, right?
Yes, Your Honor. And I'm asking today for permission from the court to have those removed so that I can
Okay, you got a
resolve the
different
blight.
you got a different situation going with that.
Okay.
Let me talk to them if we can ever get them in here. If not, I'm going to have to adjourn this and they're going to have to show up in 2 weeks in person. That's the only thing I can do. You don't have to show in person. You live up in the Upper Peninsula, right?
Yes, Your Honor.
I mean, just St. Ignace, but still, it's quite a haul. So I'm not going to make you drive here for sure.
I appreciate that, Your Honor. My P.O. box is in St. Ignace. I actually live about an hour away from St. Ignace.
North or south?
North west
Okay.
of St. Ignace.
Very peaceful up there, isn't it?
Yes, Your Honor, it is.
Of course, it's pretty cold and snowy up there right now, probably, right?
Yes, Your Honor, it is. Yes.
Nice place in the summer, though.
It is.
Okay, let me just see what's going on here. Have we heard
She's back.
anything? Ms. Summers, I need you to you need to start your video, ma'am. So I can see your face. There you go. Can you hear me?
Yes, I can.
Your name?
Lisa Summers?
Is that Stephen Summers?
Yes, it is.
And well, you have to state your name, sir.
Stephen Summers.
And Ms. Tucker Beck, your name again.
Wendy Tucker Beck.
All right. She is just out. First of all, did you two listen to and understand the rights on the video? Let's start
Judge,
with
they
you.
didn't see it because they've logged in and had problems.
You have the right to a lawyer. You have the right to proper venue. You have the right to a jury trial. You have the right to apply for funding if you would like with a variety of different agencies. You can enter into a consent judgment. You can enter into a conditional dismissal. You can take this to trial if you want. Do you understand what I just said, Ms. Summers?
Yes, I do.
Mr. Summers?
Yes, Your Honor.
Do either one of you or both of you wish to speak to a lawyer?
Yes.
Okay, folks, I'm going to give you a 2-week adjournment, and I have no choice in that, Ms. Tucker Beck. But she just got done telling me, oh, geez, do we have any more whiteout? She just got done telling me that you guys owe her a lot of money and that you got inoperable motorhomes on your property.
No, my motor.
Hang on a second. She thinks that you owe $7,175.81, which consists of $6,600 in rent, $350 in an unpaid water bill, and $225.81 in court costs. Do you agree that you owe that amount?
No, I don't.
How much do you owe?
For rent, $6,400.
Okay. Is there any other of these figures you disagree with? They're entitled to court costs.
I don't agree with the water bill, because it's not our water bill. Our water bill we have in our name, and that water bill is not in our name. It was the water bill from the person that was managing this house before we took it over, got the lease, and
Hang on. This is what I'm going to do.
okay.
I'm adjourning this until January 27th.
Okay.
I'm gonna adjourn this to what time, John? 9:30?
11:30, Judge.
11:30. And I'm gonna tell the two of you that whether you owe 6,400 or 6,950, which would include the unpaid water bill, you still owe court costs, so you're up around 6825.81 at a minimum.
That's why I need to speak with a lawyer.
I know, but you're gonna have a problem if you aren't able to pay that at the next court hearing. Do we understand one another?
Yes.
Okay, that's a lot of money. And she's also pointing out that you have inoperable motorhomes on your property, and now the city's after her for a violation of their ordinances pertaining to blight.
Well, both my motorhomes run and are drivable.
They have valid plates on them?
I just bought the one. I haven't got it registered yet.
Well,
but
you
the other
gotta
one-
get
the
plates
other one
on
does.
those. You gotta get
Yeah.
plates on those.
I know. I haven't
Okay?
had the chance to go down
Well,
and do
you
it
got
yet.
it. When did you get it?
About 2 weeks ago.
All right. What are you doing? You working a lot?
No.
Well,
I've
why
been
didn't
sick
you
with,
go-
I've been very sick. So I
Go
haven't had a
get the
chance to get down.
plates. Go
I
get
will.
the plates.
No problem,
okay?
but they haven't said anything to me.
Well, they said something to her. She's the owner. Go get the plates.
Weird.
Make them operable. Got it?
Okay. Yep.
All
No
right.
problem.
We'll see everybody here January 27th at 11:30. If you think you can't properly log on, you're gonna have to show up in person, Mr. and Mrs. Summers, okay?
All right. Thank you.
We were patient today. I won't be next time, okay?
All
Thank you
right.
very much. Have a great day.
You too. Bye-bye.
What do I have at
Thank
10:30?
you.
Thank you.
You have 3 and 10:30.
Is any lawyers out there for the 10:30s?
No, Your
Jennifer.
Honor, just the plaintiff on the small claims.
Oh, I got a small claims. That's nice to know. Where,
Well, that's the returning on Lessel. You had him coming back today.
all right, can you guys hand me that file? Is the defendant here on that? Is
Looks
the
like he might be
plaintiff-
in the courtroom.
Is the plaintiff here on that?
Plaintiff is on Zoom because they're out of town.
All right, let's go. Come on up here, guys. Tony and Brenda Lessel versus Don's Home Maintenance, 2504042. Come on up.
With the point.
All right. Lessels, I need you in here.
We're here.
Well, I need you to, I need to see you. You gotta you gotta start your video.
Okay. How do you do that?
If I may, Judge, Mr. and Mrs. Lessel, there should be a little icon of like a movie camera down in the left-hand corner with a line through it. You want to click that so the line goes
What's
away.
your name again, sir?
Donald Skritsky,
See it.
Spell your last name.
SKRZYCKI.
There's the video right there. Okay. That didn't do anything.
And
Do you see us now?
You own Don's Home Maintenance?
That's correct.
You're the principal, the president.
Yes.
And let's just wait till they log in.
We're still trying. That's just,
There we go. We can see you now.
okay.
Okay. No, we can't. That's another lawyer. I can't
Apologies.
see.
Yep.
him.
Nope. All right,
Oh.
Mr. and Mrs. Lessel, we still cannot see you. Can you see the little icon with the video camera?
Yeah. Yes.
Okay.
I
Did
clicked
you?
it.
Okay.
It says unlock A26 to start your video. So we have to go to settings, I guess, and unlock something.
I suppose.
I never
Can you?
seen it. I never seen something being locked. Is Darren Richard Hall here? Jennifer?
Your Honor, Judge, or I'm sorry, Your Honor, Mr. Hall did not check in with us. He's in the.
Mr. Canfor,
Oh,
I've got to give
you
him
know-
15 minutes. This was
Judge, he is now logging in.
good. Mr. and Mrs. Lussell can try to connect. Mr. Hall, there you go. This is Belinda Sikowski versus Richard Hall. Have a seat, sir. It's 2505232. You can sit right at that table. Mr. Hall, your name?
Richard Hall.
Mr. Camphor?
Yes, good morning, Your Honor. Darren Canfor on behalf of the plaintiff, Ms. Sipkowski.
Mr. Hall, did you listen to and understand the rights on the video?
Yes, sir.
Do you wish to speak to a lawyer?
Everything's on. I can't afford one, sir.
I mean, they have lawyers available if you want to talk to somebody.
Okay, please.
You intend to apply for funding?
I'm not sure. I don't know if I can or not.
Well, you can apply. The question is, do you qualify? Do you work?
I lost my job, which is why I'm in this situation now.
All right. Listen, I'm going to adjourn this to January 27th. Is that going to be at 11:30, Jen?
Yes, Your Honor.
At 11:30. Now, we're going to tell you the phone number. You can call the lawyer. Counsel, tell me the balance owed as of today. Just the total balance. I don't need a breakdown.
All right, 1 second. Sorry, Judge. I would have, let's see, 41. It was previously 4125 as of December. So add on another $1,375. So it's roughly
5,500?
5,500, yeah.
All right. So, Mr. Hall, you're going to end up having to pay that. If you don't pay it by the next court date, I'm going to have to give them a judgment. You can't apply for funding. If you want to come up here, we're going to give you all the places that you can apply. And then you're going to have to submit your application that shows that you applied for funding within 5 days. Department of Health and Human Services, Local Coordinated Entry Agency, HERA, Federal Help for Homeless Program. You can come up here. They'll give you all the agencies you can apply with. We have a list of that, right, Jen Wiseman?
Yes, and it should have been attached to his packet he received. We always put it
should
with
be
it.
attached to your packet.
Okay.
But if you apply, we need you to submit that to us within 5 days showing that you apply. I'm adjourning this to January 27th at 11:30, okay?
Okay, thank you, sir.
Best of luck. Thank you. South Point Square versus Brandon Harris. Well, I'll see you here on the 27th, Mr. Canfor. Thank you.
Yeah, thank you, Your Honor. Yep.
Do I have them out there, Landau's office? And do I have
No, Your
Brandon?
Honor,
Oh, we can see that.
Folks, I don't know what to do. I mean, are you coming home anytime soon?
We can see you.
Well, I can't see you and I can't handle a case if I can only see a black screen. When are you coming home?
June.
Well, I can't adjourn this to June. I mean, one or two things have to happen. I'm going to give you your choice. One or two or three things. You can either agree to dismiss this case without prejudice, Mr. Skursky. Are you agreeable to that?
Oh, sure.
And then you can refile it when you get home, but I cannot conduct it, or you can come home, fly back from Florida, I think you told me you were at, and I will handle it that way, but it's got to happen one way or the other. What did I do with that phone?
See if we can get this screen.
John, do you have that file? Did I give you that? I keep putting them up there. Russell versus Don's maintenance.
Judge, if I may, just so they know, it looks like their camera is locked. At least it's what it's showing on our screen.
I've seen a situation where it's locked like this. Not one time, all the times I've been doing Zoom. I have never seen that. It's Don's maintenance, Lessel versus Don's maintenance. Small claims.
Mm-hmm.
Did I give?
Darn it.
Do you have Lessel versus Don's maintenance down there by chance, you guys?
I gave Sadie all the time there is, George. I don't know.
She handed it to me. I called it.
Yeah, it's just a paper.
My mistake. So what do you want to do? You want to dismiss your case without prejudice and refile it? This has to do with an incident in November of 24, and I'll waive the filing fee. Jen, we can do that, right?
Yes, if it's got to be reserved, though, we can't. I don't know if you can. Okay.
So what do you want to do, Mr. and Mrs. Lessel?
Refile. Well, we're gonna have to refile if we can't get this thing to work here. I don't understand why it's.
Jennifer, give me an order to dismiss without prejudice.
Put your phone on. Maybe it doesn't matter.
A small claims case. I'm going on to the other one. South Point Square versus Brandon Harris. Stay right there, sir. 2505234. Good morning, Mr. Mudar. Your appearance?
Good morning, Your Honor. Max Mudar on behalf of the plaintiff.
Is this gentleman here, Mr. Harris?
Your Honor, Judge, he did not check in with us.
Yeah. I'm going to give you a default. You can go ahead and proceed.
Thank you, Your Honor. At this time, plaintiff moves for the entry of a default judgment. This is a non-payment case for possession only. We've got a rent to retain on this matter in the amount of $1,858.23. Court costs being $182.04, giving us our grand total here today.
Do you include late fees in this?
We've got late fees, but I've waived them down to the your required $70, Your Honor.
How much do you have in just past due rent? How many months of late fees?
We've got 2 months of late fees on here.
So that's 140. That means it's 17, 18, 22 in past due rent, right?
So we've got 1,900, but that's with the court costs. Removing the court costs out, we've got 17, 18, and 19 cents.
All right, and then you got 140 in late fees and 182.04 in court costs. Your total is what?
$2,040.23.
Default judgments entered in favor of the plaintiff and against the defendant.
Thank you, Your Honor. I believe that's the only one
Date will be the 22nd. Please give me that today, will you?
Yes, Your Honor. I'll have that sent out to you in just a couple of minutes here.
Thank you. Back on Lessel versus Don's Home Maintenance, 2504042. Mr. and Mrs. Lessel, your name again.
I'm sorry, Tony Lessel.
Ma'am?
Brenda Lessel.
You guys were able to connect last time. I don't know what happened.
I don't either. I did it on my phone. But we're on a laptop.
I'll just make a note. You're not coming back to June till June. And I just want to be clear. Do you agree, Mr. Skrisky, that they can dismiss the case without prejudice and refile in June?
Yes.
And you agree to that, Mr. and Mrs. Lessel?
Yes. Yes.
Filing fee will be waived. And then I'm going to want everybody in person when you guys do this again. You're going to have them reserved and you're going to have to pay for that. I'll just indicate cases dismissed without prejudice per agreement of the parties. And when case refiled, no filing fees. Filing fees are waived, but you'll have to pay for the service fee.
Okay, fair enough.
What started as a routine court appearance quickly turned into a powerful lecture about addiction, honesty, and the limits of a judge's patience. The defendant stood before the court facing her fourth alcohol-related offense before the age of 40. According to the judge, she had already received multiple opportunities to change her behavior. Previous offenses, court supervision, and alcohol monitoring programs had all been designed to help her avoid making the same mistakes again. But this hearing was different. The judge explained that he had originally believed the defendant could benefit from a sobriety-focused program. In his view, treatment and accountability offered a better path than simply imposing punishment. However, there was one problem that the court could not ignore: honesty. As the hearing continued, the judge expressed concern that the defendant was denying alcohol use, despite evidence that convinced him otherwise. He told her that addiction often comes with denial, but recovery cannot begin unless a person first admits there is a problem. The judge stated that he could not help someone who refused to be truthful about their actions. Then came the moment that changed everything. The judge informed the defendant that he was revoking her bond. He explained that she would lose the money already posted and would now face a much higher bond requirement if she wanted to be released again. According to the court, the original bond amount had been set lower because the judge hoped she would take the situation seriously and comply with the court's orders. But the judge felt that trust had been broken. When the defendant attempted to argue for another chance, the judge made it clear that his decision was final. He warned that the current consequences were minor compared to what could happen if future offenses resulted in felony-level charges. More importantly, he expressed genuine concern that her continued drinking could eventually